break at 5. I've got to get a makeup exam started in the other room, so I apologize for the break we'll have to take, but I do have to take a break. We're on section 2. No, I'm sorry. We're still completing section 1. And there are various articles here and the like to talk about, which we will. But there's also one of the rules mentioned, and I want to talk a little bit about this, and then we'll move to the mediation and the like, and hopefully your role as a peacemaker. But let's take a look at Rule 65, because a lot of remedies turns on, oftentimes, requests for injunctive relief and the like. And so you should be thoroughly familiar with Rule 65. When you're asking the court for an order to do or to have someone do something or to prohibit someone from doing something, in the civil context, that's going to be governed by Rule 65. And if you looked at Rule 65, you'd see the things we've talked about before is that there are temporary restraining orders, there are preliminary injunctions, and then at some point there are permanent injunctions. And to some extent, the procedure is set forth within the rules as to how you would proceed and what's required in order to proceed. But requests for injunctive relief generally are start, at least in the civil context. I know some of you probably have some familiarity with restraining orders issued in the context of abuse petitions and the like, hopefully not personally, but some of you are aware of that, and those can start without complaints. But in a civil action, in order to have standing to pursue an injunction, you must have a legal injury. If you have a legal injury, you have to establish that in the complaint. And so your request for injunctive relief is preceded by filing the complaint. They can be done simultaneously, but just as in any complaint, you're going to name the parties, you're going to plead your facts, you're going to ultimately tell us what happened, and you're going to make a request for relief. If one of those requests for relief contains request for injunctive relief, either a temporary restraining order, preliminary injunction, or permanent injunction, then Rule 65 talks about how you would proceed with respect to that. As a general matter, if you're seeking and filing a complaint for injunctive relief and seeking injunctive relief, then you do so either by way of a verified complaint or with an affidavit that supports the facts in the complaint. A verified complaint is nothing more than a complaint that has what we call a jurat on the bottom of it, J-U-R-A-T. And what the jurat is a couple lines that say, I, the plaintiff in the above entitled action, state of my own personal knowledge that the facts herein stated are true, except such those as are listed upon information and belief, and those of which I believe to be true. Signed under the pains and penalties of perjury with a date. The reason that language is required is because the allegations in the complaint are nothing more than allegations that the attorney has made, and it really is the attorney who has made them, because the client doesn't sign the complaint, you do. And so absent the jurat, there is nothing that establishes in any way the truth of those allegations until either the defendant admits them, which isn't likely, or you establish a claim at trial. And so therefore the jurat on the complaint is necessary. And if you don't have the jurat on the complaint, then you have to move with respect to injunctive relief with an affidavit. And an affidavit simply says the same thing. Affidavits are based on someone's personal knowledge, and they are signed under the pains and penalties of perjury. And what that does is that gives the court some ability to look at those facts and determine that they are facts, not simply allegations. So you've got to remember that when you move for injunctive relief, oftentimes the complaint is filed. If there's no jurat, there's an affidavit attached to it. There's a motion for injunctive relief that would be filed as well. And oftentimes, if it's a TRO or preliminary injunction, you're also filing a memorandum of law in support of that proposition as well. The procedure is set here. Oftentimes, you could try and get a TRO without notice. But when we think about without notice, oftentimes we're thinking about no formal notice of a summons and the like. But if you are seeking a TRO, while it can be issued without notice, courts are reluctant to, obviously, because of the potential violations of due process. The defendant's or the opponent's right, the opportunity to be heard, to get notice and be heard. And so even where it's authorized, it's going to take an extreme situation where the court would be willing to, absent any type of notice, even a phone call notice to the other side telling them you're seeking it, that the court would do it. So you should reserve it for extreme situations. I think especially early on, until you've got a good handle on what those extreme situations are, you need to be careful, because the first response any judge would give you is without notice, no notice. I mean, that's a due process violation. What is the extreme situation that exists here such that we don't have an opportunity to give the other side their day in court to be heard? And doesn't need a summons, so we have to wait. Sometimes it's just simply you tell them I'm going to court today at 2 o'clock. If you know who the attorney is, sometimes you have engaged in discussions beforehand, hopefully, and then at some point you go in for injunctive relief. And there are situations that would warrant it. The other side's destroying evidence. The other side is doing something that if it's not stopped, you really will suffer immediate, irreparable harm or injury. Those are the types of situations where we may not be able to wait. We certainly can't wait the traditional notice, 20 days to respond, and then get to court. But what that means is that there will be times where I don't have a choice but to go in without notice. You want to make sure you reserve those for the appropriate circumstances, because I think the court oftentimes will look somewhat askance at the cry of wolf that it's such an extreme situation if it truly isn't. And then once you've done that once, then the likelihood is they're not necessarily going to believe you the next time you tell them that this is a situation that warrants a TRO. Oftentimes, the TRO, when you do go in and say it's denied, or even if it's allowed, we're going to get a relatively short notice on the hearing for the preliminary injunction. It might be 10 days later, it might be 20 days later, but you better be prepared then at that point to be able to go forward on your request for a preliminary injunction. And at that point, you likely will face opposition, and we're going to read some cases as to what that hearing and what that process then would look like at the preliminary injunction stage. It may include an evidentiary hearing, so you better be prepared to actually put witnesses on and cross-examine witness, put documents in, and prove why you can establish what the five-part test is. The five-part test for injunctive relief, and we're going to see it in Weinberger, and we're going to see it throughout a bunch of different cases, but you must establish that the have no adequate remedy at law. And what that means is money damages won't make the plaintiff whole. The modern read on the interpretation of no adequate remedy at law isn't that necessarily that money damages won't make you whole, it's that money is not as complete an effective remedy as injunctive relief would, which gives you some additional latitude to seek injunctive relief. But oftentimes the first response on injunctive relief is that money damages will more than suffice for whatever has taken place here. And if money will, there's no reason to grant the extraordinary remedy of injunctive relief. No adequate remedy of law. The number two is likelihood of success on the merits. And that simply boils down to who's more likely to win this case, plaintiff or defendant. And when I say plaintiff or defendant, to some extent that's incorrect, because if a defendant asserts a counterclaim, the defendant now has a legal injury as well. The defendant can seek injunctive relief. Sometimes you'll have cross arguments on injunctive relief. Don't enjoin me, enjoin them. Okay? Best defense is a good offense. So either party, assuming that they have a legal claim asserted, can seek injunctive relief. Likelihood of success on the merits. The more likely you are to win down the road. Recognizing that down the road could be a year out, 18 months, even 2 years out. I've had pieces of litigation that have taken 4.5, 5 years from the beginning to end. And there will be times where we need to keep the parties at peace while that case is proceeding, and therefore we need injunctive relief. But what you have to remember is that the likelihood of success, it may well be over relatively early if I can win on a preliminary injunction and hold that ground, depending on what the order I'm seeking is. That may make it really almost compulsory for the other side to settle at some point than to have to suffer under the terms of that request for injunctive relief. The third part of our test, immediate irreparable injury. Immediate irreparable injury. And it means just that. It's not that you're going to suffer something down the road. It means that you're suffering an immediate injury that perhaps, if it continues, cannot be fixed. Not perhaps, it can't be fixed. Immediate irreparable injury. 4, balance of harms. What are the competing harms here to the party who says that they need the injunction, as to what are the competing harms to the party who will suffer as a result of the injunction? That has to be balanced. And the 5th part of the test is, what if any public policy considerations are at work here in this case? And again, when we think about public policy considerations, there are some that are not readily apparent, but there are other cases that may dominate the discussion. And if we've got public policy concerns, they have to be weighed as well. All of that goes into the judge's decision as to whether injunctive relief should be granted or not. And injunctive relief is, in fact, the judge and only the judge's decision. All right, injunctive relief, there's no right to a jury trial, and it almost always rests with the sound discretion of the court. What's fair? What's just? So the court has a great deal of latitude in deciding whether injunctive relief issues or not. If you looked at Rule 65, it talks about the court can consolidate these hearings, and so your entire case could be consolidated relatively quickly, so that we might be going to trial in 3 months as opposed to 2 or 3 years, 6 months. Once, if an injunction is granted, the other side has a right to try and dissolve it. If the injunction is granted, there should be security posted, a bond for that injunction. And the bond is supposed to provide for security in the event the appellate court later determines that the injunction was improvidently granted. And that bond, that security, would compensate the party who was enjoined for any damage and costs they suffered as a result of that. So another means of opposing the injunction is to ask and to show why you need a high bond. You're all too young to remember it, but when Danny Ainge was a player for the Toronto Blue Jays, the Celtics wanted him to become a basketball player with them. And the Blue Jays were successful in seeking injunctive relief, but then the Celtics wanted, and Ainge wanted an extraordinarily high bond because Ainge was saying, well, you're taking me out of my living here that I can make a lot more money with the Celtics. He wasn't a very good baseball player. And the fact is that case settled over the amount of the bond that the Blue Jays had to post. And a lot of cases, depending on the size of the bond, you may not even, those players, obviously, those parties obviously could pay whatever bond anyone asked for. But at some point, the bond becomes an additional thing we fight about and a means of trying to ensure that the injunction doesn't ultimately get granted if the bond is sufficiently high, because that means you've got to post security in case it's later determined that it was a mistake. An injunction has to be clear as to what it is that the party is required to do or not do, because it carries with it the threat of contempt. And so if you're seeking injunctive relief, you need to be clear as to what it is you want that person to either do or not do. And oftentimes, as you might guess, they're going to go to their lawyer and say, well, what can we do? What am I prohibited from doing? Conversely, what can I still do? And if the order you wrote that you told the judge you needed doesn't cover the situation as well as you might have wanted, that's too bad, because after the fact, they're not in contempt of the order unless the order prohibited the activities that they were engaged in. Any questions on Rule 65? And we're going to look at the cases and the like, but I think it's important to recognize that this really, the procedure, the terms, and what you need to do in order to obtain it really start with Rule 65, and then ultimately there's an incredible amount of common law that goes into it. But it starts, the modern rule starts with both, whether we're in federal court or state court, Rule 65. Questions on Rule 65? Well, let's talk a little bit about lawyer turns peacemaker and some of these articles about mediation and the like, and then we'll move to Weinberger today. I have a couple problems with mediation and the like, ADR in general, and then I shouldn't say they're problems per se, but here's my starting point. I think it's important for you to try and settle the cases as early as you can, right? Obviously, your clients would like whatever it is they want, would like to do it with less expense and do it quickly. The problem in my experience with that is that oftentimes I find that the parties are only willing to turn to ADR after they've invested some significant amounts of money and time in the actual litigation process itself. So I can tell you that you should consider alternative dispute resolution, and you should. You should consider every opportunity you have with the other side to try and talk about settlement. But I can say that as a professor to you, but I know as a litigant and a lawyer, I'm not going to go hat in hand every opportunity to say, oh, please settle. I'm more likely to beat you about the head and face till you come and say, well, what can we do about this? So I'm trying to balance what I know I should tell you with what the reality is as well. And I do think, honestly, from the standpoint of litigation, especially civil litigation, oftentimes the settlements come from a position of strength, that it's a recognition that I'm more likely to beat you, and so maybe you have to sit down and think about it because you've got a lot more to lose at trial or in the process itself than you do right now. And that, I think that's 110% the reality. Does that mean I won't say, listen, the case is sufficiently clear that we ought to sit down sooner rather than later? No, I'm going to say that, but if I'm at $1 million and you're at 5,000 and we're right, we haven't got anywhere yet, I'm probably not going to sit and talk to you much. And it doesn't make sense early on to do that. But with that said, I have settled cases really before any discovery has begun. The litigation was begun. We decided that we both thought it made sense to see what a mediator would think earlier on. We used the mediator from the federal court, which is free, and that's a significant advantage. Obviously, free is always better. So sometimes you get what you pay for, but I haven't found that really to be the case with the ones that are part of the court process, because oftentimes they're experienced magistrates or judges or even advocates. So I think that is this real strength of ADR. Someone has to, the person who is the mediator or whoever is going to be the neutral or conciliator or whatever the process you're using, so that they call them that name, they have to understand the law, they have to understand the strength of the potential case, so where it stands with respect to complaint answers and discovery. And then they've got to have some experience, in my opinion, because it sounds terrible, but I'm not, I've done this long enough that I'm not going to listen to someone who isn't a lawyer tell me about the strength of my legal case. And I'm not going to listen to someone who hasn't been a lawyer long to tell me about the strength of my case and the merits of it and what it should settle for. And so to me, I've found the most benefit, and this is my perspective, is judges, magistrates, someone who has seen enough of these cases to understand what the value is. Because I think early on, it's a real problem for you guys, if you think about it, is what's my case worth? I get calls all the time. I've got this or that from students or graduates. what should I be looking for? And that's hopefully what we're going to talk a little bit about as we go through the course of the semester, because, okay, it sounds like a lot of money. Realistically, what's it worth? A case is worth what the likelihood of success is times the likely value of the case. So if you've only got a 60% chance of winning a $3 million case, the math says that that's worth what? 60 times 1.8? Is that right?
Yeah.
Huh?
1.8.
That's not bad. That's not a bad reference point, I think, to sort of just do it sort of mechanically. But obviously, that's very rough. But I mean, realistically, if you're asking me for $3 million on a case you got a 60% chance of winning, and $3 million is the max you're likely to win, and you're saying $3 million is it, I'm trying the case, right? Realistically, I can't lose any more than you're offering to settle for. You've given me no option. And so when we think about valuing cases, when we think about mediation and using the process, what we have to have, at least in part, is a realistic assessment of what the case is worth. The reason we're in mediation, the reason we can't do it on our own, is oftentimes you have an unrealistic expectation on both sides as to what they think the case is worth. And so that's where the mediator, the conciliator, the neutral comes real handy, because I may be dead on. But if I'm working with a whack job on the other side, then I need you to move them. And if they're not willing to move for me, maybe you can have more success. And I've often found that if they agree with us, then we can move them a little bit. And so, but to do that, I think effectively, it takes a good, experienced, whoever is the mediator. And you still prepare your attempt to mediate, to have your case heard, like you would litigation. I bring my strongest exhibits. I may bring my best witnesses or affidavits or pieces of evidence so that you can look at them. And so it's still an advocacy stand you take. And if we can get to where we need to get to, great. And if we can't, we can't. But the problem, as I see it, is that oftentimes early on, it's not in the. I tend to do plaintiff's work virtually exclusively. It's not in the defendant's interest early on, defendant's lawyer's interest certainly early on, to sit at the table and try and talk about what a reasonable solution to the monetary solution to the case would be. And the reason for it is they haven't maxed out their hourly fees yet. And so some of you will be doing defendant's work. Tell me what I know what it is, but you tell me what you think the incentive for you to settle that case early on is.
If it's a big client, then it's going to give you repeat business?
Yeah, that's what I think, Neil. And I think you have to think about it that way. A happy client means other clients, right? Happy client means referrals. If they feel you've been gouged, you feel you've been taken advantage of, they're never coming back. And they're going to bitch about it, and they're going to tell all their friends about it, and you got trouble. But a happy client, hopefully, will mean that they're going to send others your way. Even adversaries will send others your way if you are sufficiently professional and win, beat them. You'll get clients from that way as well. But the fact is that from a standpoint of at least the pure economics of it, well, I can make $5 or $10 grand and still settle relatively early. And that's the problem, is there's going to be some feeling out process. And that's why, to me, I can tell you, and that's why I start with mediation, is that there's been a couple, I should say. And some of them have been without mediators, and some of them have just been, so some of them have been without, where we had sat down, we had reasonable expectations. No one wanted the information in the public record. There were advantages to just being done with it early, and we could do that. There are others where, upon seeing the complaint and the answer, we went relatively early on, found a mediator that we could live with, and then were able to settle it early. Most of my experience as mediation is way, way on the back end. I was involved in the church cases with respect to the mediation on the sexual abuse claims. Only after they lost at the Supreme Court level did they really want to sit down, and then they came up with a global plan. I was involved in this nightmarish piece of litigation against a big box retailer that at the end of the day they ended up paying much more than the initial demand 3 years earlier, and likely spent well in excess of $250,000 in attorney's fees to defend the claim that they should have seen was bad. The mediation in that case alone, for single-day mediation, this was the most expensive I've been involved in, was $5,000 for a single day. That's what the mediator got. And then that becomes a question too: is who's going to pay? I wasn't going to pay. I didn't need a mediator, so I knew what a case was worth and what we needed. If they needed help to get there, that was on them. We refused to even pay the mediator fee if they so, because to me that's another. You can negotiate that. Normally, the answer will be no. But the fact is that, to me, I needed to see more good faith by them, because we were miles apart still on the money when we sat down that morning at 9:30. I mean, miles apart. Miles apart. Miles apart. Even that morning, after 2.5 years of litigation, about 40 different depositions around the Northeast, their offer that morning was $10,000. I was still at north of $2 million at that point. I got up. I was ready to go. I was pissed, as you might guess, because we're a month to trial, and I don't care if we try it. I frankly still would prefer we had tried that case. And so the fact is, I think the mediator did an extraordinary job that day. Part of it is just keeping us in the room, because I was ready to leave. He said, at least they put something on the table, right? You have to look at it that way. So, does he really tell me that? So, do you want me to say? So that's the way we're going to go. So you want me to go? Okay, 1.95. Okay, that's the way we'll do it. We'll go in $5,000 increments from here till we get to where we need to be. That's the way we're going to do this. He said. Yeah, he was a professor at Suffolk. He said, "That's what it takes us to get there. Why not? Is it that bad?" And it was messy. It was bloody at times. And somewhere around 9:45 that night, and I think he did a great job, we were able to resolve it. So sometimes you need that party, but my experience is, unfortunately, the incentive for the defendant is when it's the midnight hour and it's fish or cut bait or electrocution, that's what sharpens the senses and the mind. So and we'll talk a little more about the articles, but I hope you look at the articles, and I hope you always think, and I think any civil case, it's got its peaks and valleys, and the idea is you never want to settle if you got your ears boxed in. Ideally, you'd like to settle here, but a good litigator knows I'm not even going to talk to you at that point. But what you have to remember, and this is a lot of experience, is that there are days you come out of court where you say, "Oh, I got screwed today. I got my ears boxed." Whatever the rulings were, whatever the witnesses you can't call, you got to recognize tomorrow's a different day. I play a little game with myself. Would I rather be us than them or them today? Because that's the way it goes with cases. You try cases that some mornings are better than others, some afternoons are better than others.
It's 5.
Oh, it's 5 o'clock? Okay, let me go start them.
That clock.
Thank you, I appreciate that. And let me go start them, and I'll be right back.
They went to litigation, so I wanted to stop being sued. So I went, but I probably
When in the process, George? Like after the litigation had begun or before?
no, pretty early.
Okay. And so, what are your thoughts?
Well, I mean, I understand, like, my lawyer had a job to do, but I did feel like my lawyer went into mediation telling me, "Oh, we'll be out of here if they make any ridiculous demands," and then didn't really, like, for lack of a better term, like, turned on me just to resolve it,
Yeah. Okay. Okay, I respond. If you want to say something, go ahead, Brian.
Yep.
Remind me. I want to tell you. I'll tell you a very quick story about that. Go ahead.
I was involved in mediation. I had, basically what I did is I brought an action against a business partner. So I was involved in mediation. And I think about 2 years after that, I was in arbitration. And I'm going back to arbitration in about a month. What do I think of it?
Are you required under the terms of your business agreement to arbitrate, or is that something you
No.
Okay.
What happened is that we just chose to arbitrate because it wasn't going anywhere.
Mm-hmm.
And that was the end of it. So what happened, And I think, again, this goes back like 5.5 years now. So what happens initially is the court mandated a mediation. And that was a disaster, because it probably lasted about a half hour.
Was it with the court mediator or outside?
Court mediator.
Okay.
Because that's a point, because it's free.
Right, exactly.
Now, all of a sudden, you jump up and you have to pick an arbitrator. And the price goes up. Now you start paying. And in this particular case here, the arbitrator was a retired judge. He had just retired. And now he's actually he works in Boston. He's an attorney, but he's a retired judge, but he works for a Boston law firm right now. So the actual arbitration lasted, I would say, for almost the entire day. It started at, say, about 10 o'clock, and it lasted till probably like 4 o'clock. Had a break at 12. But we presented both sides. Now, here's my problem with it, okay? There were 3 issues that we had. I had actually sued a business partner. So we had a salary issue, we had an equipment issue, which was $100,000 worth of equipment sitting in a place I used to work at. And then there was a receivables issue. So what happened was that the judge that particular day decided to do the 2 issues. Oh, the arbitrator. I told him the judge, but he's a retired judge. The arbitrator decided to do the 2 issues from 1 to 2. And then we got to bring back a CPA for the 3rd, but that hasn't happened yet. So in the process, what I had to do was file it's called an award. We had to file an award, because I was actually awarded money
From the arbitration.
for the first time. Unfortunately, we're going back a year and a half. I didn't even see the dime yet. And that's because the 3rd part wasn't done. So I had to go back to court, and what they did is they dismissed it with prejudice. Meaning, okay, we're not going to do anything but now. When you come back, you call the arbitrator back, have him come back, and then we'll do it all over again. So that's where I'm at with it now. Now, on the other hand,
Sounds like you're very pleased with the whole process.
No. Okay. See, the thing is, I think I'm getting what I want, but the problem is the time length.
Yep.
That's the problem. I could have probably, I would have gone to court in a second, and I still would have. But the thing is that at the time, it's okay, we can do the arbitration. I thought, okay, we'll be over it, it'll be done. But it wasn't. And again, we're going back probably at least about a year and a half since I was in arbitration last. And now I got to come do it all over again. So at least it'll be, the finality is coming up to it. But again, am I pleased with it? Yes. But the length, absolutely not. Now that goes against the grain of what arbitration should be.
Yeah, I was just going to explain that. Arbitration is the most like a litigated result, because in arbitration, you're ceding control over the resolution of that matter to the person that is the arbitrator. And you may like the result, you may not like the result, but you don't have much say on what the result is other than to offer your evidence to that person and then to have them give you the result. And so arbitration is most like the litigation model. The rules on arbitration with respect to presentation of evidence and witnesses and the like are governed by the rules of that arbitrating body. A lot of times we'll use AAA down here in Boston. There are other agencies used, but there's some that are well-known, well-established, and so you might tend to use them. Someone's got to pay, right? Because again, we're going outside the court process that we all pay for, so you got to pay for arbitration. And with both of these examples on the table, I want to tell you something that's incredibly important that you might tend to overlook, and you cannot possibly overlook it. I talk to you guys about trying to pitch your case and get to the extent you can to get it to the right court, the right judge, even better. Don't think for a minute you have to do the very same thing with an arbitrator or a mediator, okay? I'm not going to mediate my case before someone I think I have no chance of persuading that I'm right. I'm not going to pick an arbitrator that I know, that I have reason to believe won't side with me. I am going to do an in-depth investigation before I ever agree to the arbitration process or who that arbitrator is. I want to see who they are, who we have to pick from. Same thing with respect to mediators and conciliators. I want to see the list. I'll pick 3 that I'll agree with. You pick 3. If they match, one of the matches, that's the one we go with. But there are people that I'm not going to agree with when I look at their background, I look at other cases they've been involved in. I can make my own judgment as to whether I think they can put my case together and come out at the right result, which is I win. And so when you pick an arbitrator or a mediator, you've got to do an extensive background check so that you know who they are. You know, oftentimes, not oftentimes, you've got to do that, okay? And if the process looks like it won't work to begin with, then I'm not going to spend a dime on it, and I'm not going to waste my time on it. But if I think we can get to a point where I've got a good shot at persuading the arbitrator or the neutral, we'll call them neutrals, that I'm right, well, then I'll go with it. But if not, then I'm not going to bother. And that's the other part of it. Oh, we'll go to this or that one. No, we're not going to. No, there's a million retired judges who do this for money. There's a million different agencies in Boston and elsewhere where you can check with other lawyers. The church cases were all done by Commonwealth Mediation in Boston. Paul Finn, well respected, well regarded, knows what he's doing. No one had a problem with it. You can find out, just like we check and track down judges, you can find out what the history and the respectability of those people are. And from Brian's standpoint, I mean, the problem with the arbitration, the reason people choose arbitration is it's fast. I arbitrated a lemon law case one time early on. They had a dog of a car. It took about 2 hours to put the case into the mediator. Within a week, they had a decision, and they got all their money back. The beauty of arbitration should be a quick result. Even if you don't quite like the result, it's fast. And frankly, from a standpoint of businesses, and individuals as well, we're getting too expensive. We're getting too slow, lawyers and the legal profession, and so they're looking for alternative means of getting quicker resolutions, because quicker means I can move on, and it also generally will mean less money. The problem is these other private processes are becoming relatively expensive as well, and so that's money going into someone else's hands other than the lawyers, and obviously that affects you guys financially.
I don't know if I misunderstood. Now, did you say that the court ordered arbitration?
Most of this stuff is mandated.
Well, I didn't think you said they didn't order. I thought they ordered mediation. You
Mediation.
said. Oftentimes, let me. I wanted to respond to that. Oftentimes they will say, and here's the question: even if they don't order it, are you willing to go to mediation? You're the lawyer. How do you say no? No, damn it! I want to bring them back and forth to court all for the next year, right? I'm willing to go to mediation. I'm not going to change my number. I'm not going to change my mind. I'm not going to. By going to mediation, all I've done, in my opinion, is agree to be reasonable. But if you're not reasonable, then we're not going anywhere. This is response to George's point. Just 2 quick examples. You got to be prepared to get up and leave, right? Okay, if we're not getting anywhere, I had this out in Worcester. We spent, I don't know, a couple hours. They were just bullshitting around, okay? Okay, I'll waste a couple hours. I'm not wasting the rest of the day. I've told you what the number is. You're not moving. I'm not going to change my mind. I appreciate everyone's time. We're up, okay? And sometimes you just got to get up and leave, okay? And it's because if it's not going to be fruitful, it's not going to be fruitful. You shouldn't feel that you have to settle. That's the beauty of mediation or conciliation, is you are still in charge of your own destiny. And sometimes it's like everything else. Sometimes you got to just stop the talking and walk and just not say another thing. And you know that the one out in Worcester, I knew they'd be back. I knew they had to be back. I had a stronger case. They had real troubles. They had to come back, and so they needed to know that you were prepared to walk away. And sometimes mediation, conciliation, sometimes it's effective to say we've done it, because the court oftentimes is going to want to dump the ball in someone else's hands. Your Honor, we tried mediation, didn't go anywhere. The other side has an unrealistic view of this case. That's what I think, and so don't be afraid to say it. I'll give you one last quick war story, and this is your lawyer turns on you story. This is your lawyer turns on you. I had one in federal court. It was a big case. It should have been a big case, and it was. It was an invention dispute. And we litigated that for a couple of years. And it was a cardiac catheter that my client had invented, and his partner stole it from him. And he did steal it from him, and the evidence indicates that. And so well, here's another thing to think about with your selection. It was free because it's court-ordered, court-assisted mediation, and there were two retired federal judges you could pick from. This is what they say. So you figure out which one you'd pick based on this. Basically, you know a little bit too. You can see Judge Skinner right away. Now, some of you had Professor Martin for Civ Pro, right? So you read Civil Action? Okay, and that was Judge Skinner. Okay, so if Judge Skinner, I thought, just did terrible things in that case. But you can see Judge Skinner right away. Or you can see Judge Mazzone, but his list is, he's got a 4-month backlog. So who do you want to see? You want to see Skinner? No, shit, no. You don't want to see the guy who's got nothing but time on his hands, because there's a reason why no one wants to go see him, right? And so I don't want to see Skinner. And if you knew the rest of Mazzone had a better track record at this. So you want to see Mazzone. So I don't. Listen, in the scheme of things, I'll wait 4 months, but I'd rather see the person who's better at this. Okay, so that's the way we went into it, and we did. We waited for Mazzone. So we go back and forth most of the day, and he's a nice guy. I think his niece is a graduate of the law school, and he's dead now, but he's very, very nice. And as usual, I'm being a big jerk, as he and the other side would see it. But again, you know what the strength of the case is. You know what the value of the case is. It doesn't make a difference what they keep saying. No, we're not going to go a penny above this. Then don't. Okay. I'll try the case. I don't mind trying the case. That's the fun part of it, right? It's all the prep that's lousy. It's all everything else that stinks. But to actually be able to present your case, that's the beauty of it. And if I think I can win a lot more than lose, and especially if I've got a statute involved in these cases that provides for an award of attorney's fees, I've got much more to gain, both personally and otherwise, by trying this case than to settle it. Because if I settle the case, there's no award of attorney's fees. If you try the case and win, if there's a statute, then you get, in addition to whatever other fees your arrangements are, you get an award of attorney's fees. So there's no disincentive for me to try unless you make it worth my while and the client's while, really, right, because it's their case, not to try it. So put the number where it needs to be, or I don't care, right? We don't care. This is what we do. We try cases. That's what we do for a living. So we're stuck. And Mazzone, he's a former hockey player, he's like 6'7", 6'9". I'm not small, but he's big, and he's got his black robe on. So he says, have you ever seen the back of the building here? And it's beautiful, the federal court in Boston. It's beautiful. I always saw the front until Judge Mazzone showed me the back. He said, it's magnificent back there. He said, come on, I'll show you. I'll give you a quick tour. I was younger. So we go back there and we look. He says, oh, look at this. We sit in a small conference room. He's a big guy. I'm not small, okay, but he's much bigger than me. He stands over me like this, and he points his finger in my chest. And he says, not hitting me, but literally this close. And he says, you're going to go back out there, and you're going to tell I swear to God this is true, you're going to tell your client to settle a case for the number on the table right now. He said, that's a good number. And I said, I'm not going to do that. I said, I'm not going to do that. I said, that number's not the number it needs to be. And when they get to where they need to be, I'll tell them that I think that number's good, but I'm not going to sell them out because you want to be done here. It's getting to be, this is the other thing, right? It's getting to be 3:45. I'll stay all night. You're the one that's used to leaving at 4:30. It doesn't bother me either. So, don't. But that's so when you say that sometimes, because that's not mediation when you're threatened in essence to settle the case. But this is what I want you to know. It doesn't make a difference who threatens you. You came to law school, I hope, to stand for people who can't speak for themselves. And so it's the worst thing you can do. You can call you names, you can threaten you like that. I've told you guys before, I gotten beaten up before. What the hell is that? So you can say overrule to my objection, or you can do whatever else you'd like to do. You're not going to knock my tooth out here. That's I can live with all the rest. And that's the way you've got to think about it. Is that's our job, is to not force him to settle the case because you're done for the day. Who cares? I'm here till the end. That's your job. And I think you should wear that with some pride. And the mediation part of it is supposed to be voluntary. And if it's no longer voluntary, then you can't be afraid to do the job that you set out to do, which is try the case. And that's the last part of this I want to really emphasize for you. There are a lot of lawyers that call themselves litigators. Oh, I'm a litigator. And you know what? So many of them get weak-kneed when it comes time to actually stand in the court and try their case. That invention dispute I talked to you about, he was puffing and puffing. I knew I had him at one point, and I knew he was never going to try that case. And so my number went up. That's what Mazzone was mad about, too, is that I said my number was going up at some point, month to month. And I said, the longer you take, it's going up $100,000 a month. And that's what he was mad at. He said, you can't do that. I can do whatever I want. Really, you may force me to do all this. The number has gone up. It's the way it is. Because you've got them further into the process. Right? You can't. He's not going to win. He doesn't even want to try this case anymore. He knows I've got the better evidence. So why shouldn't it go up? You force the hand. The client's entitled to get his return. It's not a 60% chance of success anymore. I told you 60% times the likelihood of the number. It's not 60 anymore. We had our final pretrial conference. I got the questions I needed to get before the jury. He got my questions. He's dead. They can answer those 4 questions have to be, on the basis of the evidence I have, almost virtually have to be answered. Now you try a case, you win some, you lose some. But I just increased the odds of winning by 20% in that final pretrial conference by getting my questions to go to the jury, not his. The number has to go up. It's not the same number it was. In the big box case, it's not the same number it was at the outset. The case is significantly stronger than it was now. And things are worse. That's the way it goes. And you've got to be prepared to say, I'll try it. Because a lot of people don't want to do that. And that's why they wait to the end to do this process. But the fact is, the facts change over time. But even this process, you have to be prepared to be the advocate. You have to be prepared to know who that neutral is or the arbitrator you're trying the case before. And you have to be prepared to stand your ground and say no, and to get up and walk. And that's, everyone wants to be accommodating and polite and courteous and professional, and all of those things you should do. You can say no politely, respectfully, we're done. And at some point, we're done. If you're not forced to settle, that's your choice. Did I go past what you want to say?
No, I was going to say I went to a mediation that it seemed like I think he was a lawyer who was sitting as the mediator. It was in land court, and they kind of make you go. I mean,
yeah.
There was a tenant issue they had.
Well, let me just, how do you say no? Because the court says, I think you should go to mediation.
You should have no good faith,
You got to go. Okay, I got to go. So I've wasted more time in court sitting around waiting for a call to the list. I'll go. And who knows? Maybe we'll get lucky, because I don't think we will. But I'll try, because at least I can say that we did it, because the next judge or the next person is going to say, did you go to mediation yet?
Yeah, it seemed like his MO was just kind of yelling at both parties until he came up with a solution, you know what I mean? It wasn't, we ended up settling just because we just wanted him out of the building anyways, but I mean, he just seemed to
It's cheaper to settle than to keep going on.
Yeah, and I mean, but do you ever have a client that maybe you were on the losing end and he was unrealistic about the number, so maybe
clients can be ridiculously unrealistic at times, but that's your job too, is to educate them as to what the value of the strength of the case is. But if they don't want to settle, if they don't want to listen, it's their case. I've told some of you the story. I was out in Norfolk probate. It was the divorce case, a horrible old divorce case. I swear to God, she had been through 10 lawyers before me. I was low man in the office. No one else who wants this one. She had taken 2 of her lawyers. Seriously, I was like 2 years out, if that. She had taken 2 of her lawyers to the BBO. She had taken a case all the way to the Supreme Court herself, pro se. And the firm had to take the client. And obviously, I'm the low man, so I've got to take the client. So we're out and off our probate. I prepared the case. It's college tuition time. It's at BC. I forget what BC's price was at the time. He offered 80%, 90% of the total cost of BC's tuition. That's what he had offered. No. She said, no, it's not enough. This is my client. Okay, talk about unrealistic clients. I said, I won't get there anyway. I said, it's not possible we can get any more than this at trial. I said, it's not likely. He's much more likely to split it. That's just the way it is that even though it's a lot of money, she didn't do badly. He's likely to split it. No. I want to hear what the judge has to say. I said, you're not going to like what he has to say. That we can't do better than this. She says, nope. And now your job, well, first of all, I got two things. A, your job is not to shove the settlement down the client's throat. Your job is to do what the client wants, even if you think it's a ridiculous thing to do, okay? And so we had that conversation that this was a huge mistake. But at the end of the day, it's her call. So she wants to try. She wants to go before the judge and try. So we go before the judge and try it. It's 2 o'clock. It didn't take, there's really two witnesses, him and her. It took a couple hours to try. She was, as I expected, it was not a surprise to me, the most god-awful witness in the world. Mean, vindictive. Some of those cases end up like that, and this was clearly one of them. Judge didn't even wait to take it under advisement. Like usually if they're going to give you bad news, they take it under advisement. She testified first. He then testified before 4 o'clock. He said, "Okay, I've got a ruling." Another not a good sign. Doesn't give her a dime. She appeared to be, well, not appeared. She was. Well, I don't know whether she was. He said she appeared to be lying on the stand. That he didn't trust anything she had to say. And she got zero. Not a little less, not a lot less. She got 0 based on what the judge felt was a mean-spirited, angry, vindictive plaintiff, most of which probably was accurate. But the good news is she said I was the best of her 10 previous lawyers. So I didn't get a BBO complaint, even though she didn't get a dime. And so, A, at the end of the day, it's their case. B, a lot of what you do is manage unrealistic expectations. And you've got to be careful, because I worked with another lawyer, and I'm not going to keep doing all this war story crap, but I worked with another lawyer who fanned unrealistic expectations and got a lot of clients because of it, but those cases all blew up, and then they complained, and they were angry that they spent a lot of money when they shouldn't have. And so you manage expectations from the outset, and you really have to be careful. Sometimes they want to know early what the case is worth. You may not know, but you've got to be honest with them and objective and say, we don't know yet. We've got to see more discovery. We've got to figure out where we're at. And it's never worth a single number. It's a range. And even when you say a range, I try the case to this side of the room, I get one number. I try the case to this side of the room, I get another. And I try it to there, I get a different one. All juries are different, so you can give them a range, but that's all you can do. But what you do have to do is, there will be times where you have clients that think it's worth so much more than it is, and sometimes the other side is a problem. They're willing to settle for far less, and that may be because of economic circumstances. They want to get it over with. They've run out of money, and that's problematic too, because they're selling themselves short, but there may be reasons why they don't have much of a choice but to do that. And again, it was funny, this big box one, he rode with me right to the end, even though he was destitute at the end, because they tried to drag it out so that he had nothing left. He had nothing left, and he was still staying strong, and they know that that's just not the way it is. Big companies, big defendants tend to try to exhaust you with what we call a scorched earth strategy. They're going to spend every dime they can to exhaust you and your client before the case is over, in the expectation that you'll walk away for significantly less. And that's the way it is. And you got to recognize that when you take on a case against a major defendant. They have more resources than you, they have more time than you, they have more lawyers than you, and they'll spend more. But that's the way it is. It makes the victory even sweeter. So read your articles. I want to talk about Weinberger. But I think there's a lot of good stuff in these, preparing the mediator and recognizing that it's not, this isn't let's go hold hands and sing Kumbaya. This is, you better be prepared to be an advocate. You better be prepared to be able to use your best evidence in a serious way so that they understand you are strong in your position and strong in the belief and the strength of your case, because it's all advocacy. And the last thing I want to mention on the mediation part of it, if you haven't seen it or been involved in it, we tend to think we're in the same room, we're going to talk in a significant way, oftentimes, other than saying hi. More often than not, the ones I've been involved in, they don't even sit in the same room beyond saying hi in the morning, shaking hands at the end of the day. The mediator or the neutral runs the rooms back and forth. So I don't even, there are times you're playing poker in the dark. I don't even know whether he's giving me the true number they're at, with the expectation that, well, later on when he puts their real number on, I'll be more pleased. There's not a lot of face-to-face, and I think there's an advantage to it, because sometimes the animosity between the parties is so much that it wouldn't help. But there is some sense of we're doing a lot of this in the dark. And you are doing a lot of it in the dark, because the parties aren't often in the same room anymore as the mediator works his or her magic to try and get them to be where they need to be. And a good mediator will work each party, not forcing them, but giving them the facts as they see it and the potential weakness. And so you'll send messages back with the mediator, recognizing that that's what they're capable of doing, because you're not going to see them face to face very much at all during that process.
Counsel too? You say animosity, or you just mean with
I think there are times where I really dislike the other counsel, and that won't serve any advantage. There are other times, the invention dispute, I really didn't like him. He didn't like me much either. Actually, the big box retailer one, we got along really. The lawyers got along really well, but the invention dispute, I didn't like his client. I didn't like him. They were liars, and they really were liars and thieves. Where I was able to establish that the scientific notebook had been falsified, I'm not so sure. Frankly, the lawyer didn't know. It took a while, but we were able to establish it, and at that point, the case was over. So I think, yeah, there are times, and that shouldn't play a part of it, and you got to be careful with that, because that's the other reason that number went up in that case, is that I thought the lawyer was complicit in part of what took place. So, but you do have to take some of that hostility out, because you shouldn't use that to punish. Let's talk about Weinberger versus Romero-Barcelo, because this is a case that many of you have read in orientation. I don't think we still read it in orientation, but we've got the Commonwealth of Puerto Rico suing the Secretary of Navy for an injunction to prohibit the Navy from continuing to use Vieques Island for weapons training. And they're bombing the waters off the coast of Puerto Rico. And what appears to be, at the end of the day, a pretty clear violation of the Federal Water Pollution Control Act. Despite what appears to be a clear legal injury, at the end of the day, the court doesn't grant, at the end of the day, the court feels that there is no equitable remedy necessary in order to help the people of Puerto Rico. And so when I read this, I'm not going to go, usually I go into a lot more facts, but you guys have all looked at this before, right? I mean, you've looked at it, I think, in orientation still. So I want to start out from the standpoint of, when you looked at this and you considered the 5 factors, the no adequate remedy at law, I mean, money's not going to help here. They don't want money, they want them out. The likelihood of success, if we look at that federal statute, there's no doubt that this is a pollutant. It is from a point source, and that, at least from a standpoint of liability under the Act, they should win. I guess if Puerto Rico fails, it's on the next 2 parts of the test. immediate irreparable injury, and balance of harms. And maybe the fifth part of the test, too, public policy concerns. Is that what happened here? Is they failed to show an injury or harm? Or is this just you're trying to sue the United States of America and stop them from doing something that they say is necessary to the national defense? You don't stand a snowball's chance in hell at getting justice under those circumstances. I mean, is it truly that they just didn't prove injury?
I think it's just public policy. I mean, if the presidential exemption wasn't there as a fallback for them, you know, I think that the court might have said, okay, there is an injunction, but at the end of the day, if they didn't get the permit, they would have got the presidential exemption. So.
But Neil, I would have felt better if they got the presidential exemption instead, because that's what the exemption is for. No, I mean, is that there is no doubt that there's even the court said, a technical violation. No.
I think bombing the island was injured by itself. It's like damaging the ecosystem, damaging natural resources. So I agree. It was just a matter of, this is the Navy, national defense comes first. We don't care about that.
Well, but let me ask you about that then, because that sort of says something pretty lousy about our justice system, no? Go ahead.
Well, real quick, I've read some of this where I just couldn't believe, agree with it at all. It said, the integrity of the nation's waters, not the permit process, is the purpose of this act. And then it goes on to say that they're not polluting the waters, yet they're dropping bombs in the waters. It's clearly being polluted. So that right there, it just almost shows, like you said, you know, you're going up against the government, you don't stand a snowball's chance in hell in this case.
But in what? Go ahead.
Well, that goes, I mean, the very statement there goes to show, because they're saying that the integrity of public waters is the reasoning behind the policy. But that's why the permit is there, to protect the integrity of the public waters. So when they violated the permit, they're also violating the integrity of the public waters. So they're speaking in circles.
Well, good. I wanted to ask you about that, because that's the dissent goes into that quite extensively. Talks about them going the circular logic. The dissent actually calls them sophists at some point. And so when I've looked at this before, I've asked you guys, if the people of Puerto Rico don't get justice, what do they get out of this case? Or do you think that this is a just result simply because it is consistent with equity, where the court has such broad discretion?
I think it's a little of both.
It's a little of both.
Yeah.
Some of it is sophistry. I'm looking at page 333 of the decision. It says the court's sophistry is premised on a gross misunderstanding of the statutory scheme. Sophistry, I looked up, it says subterfuge, duplicity, chicanery. Jeez, seems like a kind of harsh assessment calling them out on that. No? That doesn't seem, I mean, this court seems kind of angry as to what the majority does here. Not that that's uncommon, but geez, that's, I mean, they're saying it is circular, it is silly, it isn't fair what they've done here. I mean, that doesn't seem like a just result. And by the way, the dissent makes a great point about, well, it's not justice at all. It's the law. I'm trying to figure where that language is now. He quotes from Sir Thomas More. Do you see that? Oh, here it is. It's in the bottom footnote on my page 335. I want to ask you about that, because he talks about Sir Thomas More. The law, Roper, the law. I know what's legal, not what's right. Is that right? That's what you people are now? And I'll stick to what's legal. I'm not God. The currents and eddies of right and wrong, which you find such plain sailing, I can't navigate. I'm no voyager. But in the thickets of the law, oh there, I'm a forester. So you guys, as lawyers, don't do what's right. You do what's legal? Is that true?
Isn't that what we're supposed to do?
Huh?
Isn't that what we're supposed to do?
What's legal,
Yeah.
not what's right.
Well, they should align.
They should.
It's supposed to be.
But did they align here?
No, they don't.
The dissent wouldn't be quoting from this if they thought they did. I know what's legal, not what's right. So that's what I'm wondering, is you guys as lawyers, that's your job? You do what's legal, not what's right. You do what your client needs lawfully, not what's right. Right or wrong doesn't factor into how you do your job. Is that true?
If you want to win, yeah.
Right doesn't.
If you want to win,
You got to do it.
Yeah.
you got to
He
do.
doesn't care what's right, he cares what the law is.
So the judge doesn't care what's right, and you don't either if you want to win. You do what's legal.
It's what's legal that wins.
Does that notion not bother you at all, or bother? I saw Sandra saying, I don't feel that comfortable. But your own sense of right or wrong, because I look at this and I think people of Puerto Rico were done wrong here, by our own government who didn't follow the law. Okay, that's wrong. But if you were the government's lawyer, you would do the same thing.
It might bother you, but when you
Yeah,
go to
you're
court,
their advocate.
Oh, it might bother you, but you got to do what you got to do.
All right,
when
let's
you go to
not.
court, you can't tell the judge, Your Honor, this is right. He's going to say, but it's illegal.
So you don't care what's right.
Well, if you're the
You care,
lawyers,
Oh, you care. So when you're sitting there having your drink at the end of the day, say, "Geez, it was wrong, but I want to win." Right or wrong doesn't even figure into it anymore, and you just want to win.
oh yeah,
Go
say
ahead.
you're the counsel for Tassanov and that you find something the police did wrong, and you're going to say, oh, screw it, I'll leave that out because this guy should go to the chair.
Well, let me. Okay, what were you going to say? And then I want to come back to that. Go ahead.
We have defense attorneys.
So some of you, I mean, even though we have video, we have the co-conspirators talking about it, or at least the accessories after the fact, going to roll them over very quickly once their cases come up. Some of you would undertake a rigorous defense for him with the claim to the jury that it's mistaken identity. He didn't do it, the marathon bomber. Because it's legal, it's not necessarily what's right, but you don't care what's right. Do you see that little kid killed at marathon?
He deserves a defense. I mean, you know.
So he deserves a defense. So even if it's not so, go ahead.
I think it's the aggregate sum of your efforts. I mean, in the long run, if you're doing more good for your client, I think that's what I rest my hat on. That.
But when you say more good for your client, that means because we'll come back to this topic again. But what that means, getting guilty people off, right?
An innocent person going to jail.
Oh, so that's what it is, right? Getting guilty people off, pursuing claims that aren't sufficiently meritorious but legal, because you can win them, and defending people who from claims they should pay. That because it's all legal, and that's all you care about. That's because at the end of the day, that's what's good. If you do your job right, that's good.
Defending the innocent people, though.
Huh?
Defending the innocent people.
Well, but okay, and I don't want to switch from civil to criminal, but let's be honest, most of them aren't innocent, right? The only question is the guilt proven beyond a reasonable doubt, right? No, does it help you sleep at night? Because, well, then you're just fooling yourself. Most of them are innocent. Are you kidding me? But by the way, we tend to go back to the criminal stuff. In civil, it is not as easy to tell. Sometimes you don't know till halfway through it. Because I've sat there and said, at the deposition at some point, the lightning will strike and say, oh, thank God I got the guy with the white hat. Because sometimes you get halfway through and you say, oh, geez, I got the wrong party here. But you're still doing your job. But your own sense, and I'll leave you with this because I think we're out of time, right? Your own sense of right or wrong doesn't factor into the job you do because you're arguing the law as vociferously and ardently as you can, despite whatever your personal feelings are about that person and their cause. Are you all prepared to say that? Because
I think it's malpractice if it isn't.
it's malpractice if it isn't.
I mean,
but what
if you're gonna ignore
about
the law,
who you are as a human being? That doesn't factor into
Don't
your
become a
practice of
lawyer.
law? Huh?
Don't become a lawyer.
So you can't. No. Okay. So he says, don't become a lawyer. You can't be a human being and a lawyer.
That's the system we have.
No, is that that's where you're ready to go? You're going to be leaving here soon. That's where you're ready to go? I can't be a human being and a lawyer, so I'll choose law. Really? That's a choice? Because that's a choice.
Well, like Dick the Butcher said, he said, first thing we have to do is kill all the lawyers.
I know, but you know that that's a misquote of that piece from Shakespeare, because what it means is, what it really, if you want a totalitarian government,
Yeah.
the first thing we do is kill all the lawyers. So
Right.
the lawyers at one point really were the protectors of society, but now you guys don't care about protecting society, you just care about winning
Doesn't your
for money. Does that make you a whore?
In the door.
Oh, does it? Just so we're clear? Hi, yeah, it does?
That side.
That side. What?
doesn't your conscience come in before you choose the case? I mean,
Yeah.
you.
Fair enough, we've talked about that, right?
Yeah.
Because you better decide if you're going to represent Sarnath.
Sometimes you have no choice.
You got to do what you got to do. Listen, I've told many of you before, I thought Whitey's lawyers were some of the best advocates, and gave them, just as if he was a completely innocent man, their defense was superb. Would you do the same for the marathon bomber?
Yeah.
You want to keep your job, you gotta.
You want to keep your job. So what? So if you could be enormously successful and do what's legal, he gets off.
It's all about.
And your by the way, your future is made, right? Personally, you have gotten a guy we all saw kill people off. You're on easy. You're going to be one of those TV lawyers, right? Nancy Grace will be having you guys on. So that's all that matters.
But that's happened with.
I think imagine if somebody came in and dragged you out and said you're a child molester and you're innocent. I mean, yeah, that's what that's kind of what you're protecting, because.
But what would be right would be getting the non-child molester off. That would be both right and legal. Which I have no problem with. What I'm hearing is, when the choice becomes right or legal, I'm going with just legal.
But then you don't have a legal system if you just go with what's right.
So, are you, okay, and I will leave you with this last question. And I know in a classroom environment, this is all pretty easy discussion. Do you really think that that's that easy then when you go home at the end of the day and you look at your own kids or you fall asleep in your own bed, what you've done, you don't think a little more about it and say, oh, jeez, I know he's going to rape again. I know this guy's going to steal again from his business partner. I know. And now he's going to think, and by the way, he's going to come back to you. And so, it's all good.
No.
Just lock your doors and cash in with the check.
I'm going to leave you on that one.
That's a quote from a lawyer.
I'll bet it is.